Hello everyone and welcome to the Firearm Firm channel. Well, it has definitely been a rough week for the ATF and a monumental week for the Second Amendment. Yesterday I did a video on the nationwide preliminary injunction regarding ATF's final rule on stabilizing brace, and while I was coaching Little League yesterday afternoon, the Fifth Circuit Court of Appeals delivered yet another devastating blow to ATF's tyranny. Late yesterday, the United States Court of Appeals for the Fifth Circuit issued an order finding ATF's final rule on unfinished frames and receivers to be unlawful in the Vanderstock v. Garland case. For any of you who are interested in finding out the details of the Vanderstock v. Garland case, you can click on the link above, or I will put a link to that previous video down in the description section so you can watch it after you finish watching this video. This case went to the Fifth Circuit Court of Appeals after a Texas federal District Court entered a summary judgment against ATF, which vacated the final rule in its entirety. On appeal, ATF requested the Fifth Circuit to stay the District Court's order pending appeal, which the Fifth Circuit denied. So, ATF requested a full stay from the United States Supreme Court, and the U.S. Supreme Court stayed the order and judgment insofar as they vacate the final ruling pending 1, the Fifth Circuit's decision of this appeal, and number 2, either denial of cert thereafter or judgment issued by the Supreme Court after granting cert. Well, on November the 9th, 2023, the Fifth Circuit Court of Appeals issued their ruling. I definitely want to go ahead and read to you the first paragraph of the ruling, as I think the judge did a great job articulating why ATF could not do what they did. In the order, he wrote, "It has long been said correctly that the law is the expression of the legislative will. As such, the best evidence of the legislature's intent is the carefully chosen words placed purposefully in the text of a statute by our duly elected representatives. Critically, the lawmaking power, the ability to transform policy into real-world obligation, lies solely with the legislative branch. When an executive agency engages in what is, for all intents and purposes, lawmaking, the legislature is deprived of its primary function under our Constitution, and our citizens are robbed of their right to fair representation in government. This is especially true when the executive rule turned law criminalizes conduct without the say of the people who are subject to its penalties. The agency rule at issue here flouts clear statutory text and exceeds the legislatively imposed limits on agency authority in the name of public policy. Because Congress has neither authorized the expansion of firearm regulation nor permitted the criminalization of previously lawful conduct, the proposed rule constitutes unlawful agency action, in direct contravention of the legislator's will. Accordingly, for the reasons set forth below, we affirm in part and vacate and remand in part the judgment of the District Court." The court then went into a brief history of the ATF and the Gun Control Act, the GCA. In the order, the court noted that the bedrock of the GCA is the word firearm, which is defined in the GCA as any weapon which will or is designed to or may be rarely be converted to expel a projectile by the action of an explosive, the frame or receiver of any such weapon, any firearm muffler or firearm silencer, or any destructive device. The court also acknowledged that the GCA did not define frame or receiver, but that ATF had previously defined it in 1978 as that part of a firearm which provides housing for the hammer, bolt, or breech block and firing mechanism, in which is usually threaded at its forward portion to receive the barrel. ATF kept this definition of frame or receiver until issuing the final rule, which is the subject of this litigation, back in 2022. The final rule changed the definition of frame or receiver to read in part, "The term frame and receiver shall include a partially complete, disassembled, or non-functional frame or receiver, including a frame or receiver parts kit that is designed to or may rarely be completed, assembled, restored, or otherwise converted to function as a frame or receiver, i.e. to house or provide a structure for the primary energized component of a handgun, breech blocking, or sealing component of a projectile weapon other than a handgun." The final rule also supplements the definition of firearm to include weapon part kit that is designed to or may rarely be completed, assembled, restored, or otherwise converted to expel a projectile by the action of an explosive. The Fifth Circuit Court's analysis begins on page 11 of the order, and the court does an excellent job explaining their reasoning. There is a link to the entire order down in the description section to this video for anyone wanting to check it out. In the analysis, the court breaks down the two underlying challenges to the final rule, which are 1, ATF's proposed definition of frame or receiver, including incomplete frames and receivers. And number 2, ATF's proposed definition of firearm, including weapon part kits. Looking at the first underlying issue regarding the definition of frame or receiver, the court directed its attention to whether or not the ATF had exceeded their authority. In doing so, the first thing the court wrote, how do we know when an agency has exceeded its authority? Simple. The plain language of the statute tells us so. The court reasoned that since Congress did not define frame or receiver in the GCA, the ordinary meaning of those words control. In determining what the ordinary meaning of those words were, the court looked at the definition of frame and receiver in Webster's dictionary, which defined a frame as the basic unit of a handgun which serves as a mounting for the barrel and operating parts of the arm. Webster's dictionary went on to define a receiver as the metal frame in which the action of a firearm is fitted, in which the breech end of the barrel is attached. Webster's dictionary's definition of frame and receiver was very similar to ATF's 1978 definition. The next part of the order I think is important. The court wrote, after almost 50 years of uniform regulation, ATF via the final rule now purports to expand the term frame and receiver as they were understood in 1968 to include changes in firearms in modern times. But the meaning of statutes do not change with times. This court normally interprets a statute in accord with the ordinary public meaning of its terms at the time of its enactment. After all, only the words on the page constitute the law adopted by Congress and approved by the President. ATF's inclusion now of partially complete, disassembled, or non-functional frames and receivers materially deviates from past definitions of these words to encompass items that were not originally understood to fall within the ambit of the GCA. The court then went on to write, a plain reading of the final rule demonstrates ATF's error. In the GCA's definition of firearm, the first subsection includes flexible language such as designed to or may be rarely converted to expel a projectile by the action of an explosive. But the subsection immediately thereafter, which contains the term frame or receiver, does not include such flexibility. When Congress includes particular language in one section of a statute but omits it in another section of the same act, it is generally presumed that Congress acts intentionally and purposely in the disparate inclusion or exclusion. ATF's assertion that Congress has repeatedly used the language such as designed to and rarely in other definitions or statutes only emphasizes the point. Congress explicitly declined to use such language in regards to frames or receivers. Thus, we presume the exclusion of the phrase designed to or may rarely be converted in the frame or receiver subsection to be purposeful such that ATF cannot add such language where Congress did not intend it to exist. As to the first issue, the court concluded in its analysis by saying, because it clearly conflicts with the plain language of the GCA, the challenge portion of the final rule that redefines frames or receivers to include partially complete, disassembled, or non-functional frames or receivers constitutes unlawful agency action. Now, moving on to the second underlying issue regarding ATF's definition of a firearm. Here the court dove into the fact that ATF's new definition expanded the scope of the GCA definition of firearm to include aggregations of weapon parts that can readily be assembled into a functioning weapon. As to this, the court wrote, the district court correctly held that ATF has no authority whatsoever to regulate parts that might be incorporated into a firearm simply because Congress explicitly removed such authority when it enacted the GCA. The GCA's predecessor statute, the Federal Firearms Act, FFA, had specific language that authorized regulation of any part or parts of a firearm. However, Congress removed this language when it enacted the GCA, replacing any part or parts with just the frame or receiver of any such weapon. Thus, the GCA does not allow for regulation of all weapons part, rather it limits regulation to two specific types of weapon parts. The final rule ignores this change completely and improperly rewrites and expands the GCA where Congress clearly limited it. The court recognized that Congress has shown that it knows how to regulate parts of weapons when it chooses to by looking at how the GCA specifically discusses parts when defining destructive device and machine guns. The court emphasized that the word parts is conspicuously absent from the definition of firearm, despite Congress' consistent and meticulous use of the words in other statutory provisions. Therefore, if Congress wanted to regulate aggregations of weapon parts with respect to firearms, it could have. Congress, however, chose not to do so, and ATF may not alter the decision on its own initiative. ATF cannot legislate. The court then addresses ATF's argument as to why they are justified in regulating weapon parts kits in the design to or may be rarely converted to language of the GCA's definition of firearm. ATF's position is that the statute captures any item or items that may be transformed or changed into a working firearm based on the dictionary definition of convert at the time the GCA was enacted, and because a weapon part kits allow someone to convert various parts into an operational firearm, the final rule's proposed definition falls within the GCA's ambit. I love how the court responded to this. It said, but this stretches the words too far. The government wants the word convert to be all-encompassing, such that any process or procedure that could ultimately lead to a finalized firearm can be regulated under the GCA's language. The language, however, is much more precise than that. In fact, the government's emphasis on the word convert ignores the surrounding words. The GCA does not just regulate anything that can be converted, or to use the government's proposed synonym, transformed, into a firearm, but rather regulates any weapon that may rarely be converted into a functional firearm. The phrase may rarely be converted cannot be read to include any object that could, if manufactured, is completed, becomes functional at some ill-defined point in the future. This word would strip the word readily of its meaning, revert the GCA to its prior articulation in the FFA, and allow for the regulation of weapon parts generally, which, as we have seen, was not Congress's intent in passing the GCA. Look no further than the words ATF used in the final proposed rule firearm definition. It includes weapon parts kits that may rarely be completed, assembled, restored, or otherwise converted to expel a projectile. Reading converted in conjunction with the other listed verbs, completed, assembled, restored, we can see that the definition itself contemplates less drastic measures than the full transformation actually required by these parts kits. The government's attempt to use the word convert to justify its unprecedented expansion of the GCA thus collapses upon a cursory reading of the text. In the conclusion, the court wrote exactly what I've been saying about ATF creating laws in the form of rules. ATF, in promulgating its final rule, attempted to take on the mantle of Congress to do something with respect to gun control. But it is not the province of an executive agency to write laws for our nation. That vital duty, for better or for worse, lies solely with the legislature. Only Congress may make the deliberate and reasoned decision to enact new or modified legislation regarding firearms based on the important policy concerns put forth by ATF and the various amici here. But unless and until Congress so acts to expand or alter the language of the Gun Control Act, ATF must operate within the statutory text existing limits. The final rule impermissibly exceeds those limits, such that ATF has essentially rewritten the law. This it cannot do, especially where criminal liability can, and according to the government's own assertions, will be broadly imposed without any congressional input whatsoever. An agency cannot label conduct lawful one day and felonious the next, and yet it is exactly what ATF accomplishes through its final rule. Accordingly, the judgment of the district court is affirmed to the extent it holds unlawful the two challenged portions of the final rule and vacated and remanded as to the remedy. The Fifth Circuit Court of Appeals then sent this case back down to the district court to determine the appropriate remedies in light of the ruling set forth. All I have to say is, well done, Fifth Circuit. You did a great job knocking ATF off their high horse and letting them know they are not Congress. Be sure to let us know what you think about this ruling down in the comments section, along with any questions you have. And don't forget to hit that like button while you're doing it. Finally, if you have not subscribed to the Firearm Firm channel, please take a second to do so. Until next time, stay armed and educated.